Okay, well, good afternoon, everybody, and welcome to our second podcast here at the Assigned Counsel program. We're unofficially calling this program Asked and Answered, not because we seek to be redundant or to have an objection sustained, but we couldn't think of a better one. So that's what we ended up with, Asked and Answered. Uh, I'm Tim Franzik, and co-host is Nick Texedo, who deserves credit for coming up with the podcast idea here at Assigned Counsel. We are thrilled today to have with us a guest who's got a most outstanding career, the Honorable Samuel L. Green, who is the longest serving justice of the Appellate Division, 4th Department. In fact, he's got a courtroom named after him. I don't know too many people who are still around who can say that. He also has an endowed scholarship in his name at the University of Buffalo Law School, as I understand it, Judge. Back in 2015, they saw fit to honor you and the students with a scholarship, and that's your alma mater, right? UB Law School.
Yes.
Class of '67.
Yes.
Okay. And I could spend an hour going through your resume, but I'm going to choose not to at this point. But first, I'd like to welcome you and say thank you for taking the time to be with us today for this conversation. So, thanks for being here.
I'm glad to be here.
And so Nick and I are eager to talk to you a little bit about your perceptions and observations about, say, the evolution of criminal procedure law, in particular some Fourth Amendment stuff, and maybe also talk about something that has always been a mystery to me, how cases get heard and decided in the appellate division and how you go about deciding a case. But before we get into that kind of stuff, what I wanted to do to kind of fill in the blanks a little bit, because I know judges tend to lead somewhat solitary lives, at least while they're on the bench, right? I'd like you to tell us a little bit about yourself, beginning at the beginning, if you might, because I'm interested in knowing where did you grow up and what were some of the things that influenced you growing up in terms of your decision, A, to become a lawyer and then a judge?
Mm-hmm. Yes. Well, actually, I was born in Alabama, but my family moved to this area when I was in about the 3rd, 4th grade, and we lived in Tonawanda. My father worked at a factory out in Tonawanda.
And what was it that drew you from Alabama, or drew them from Alabama to the Buffalo area?
Well, actually, my father was recruited to come and work in the factory because it was during the war, Second World War, and they needed able-bodied men because women couldn't work in some of the jobs, the hard-working, labor-type jobs in the plant.
They probably could, they just wouldn't let them, right?
Yeah, well, but my father was recruited to come, and he came, and my mother and a couple of my younger brothers and sisters, and then we came a little later. So I went through the Kenmore school system. I didn't finish the Kenmore school system because my family moved into the city of Buffalo, my last year, and I had to attend Hutch.
Hutch Tech?
Yes, Hutch. Well, it was Hutch Central at the time.
Okay. What year are we talking now?
And I graduated in 1952. Okay. And so I went to college right after that. I went out to Buffalo State, and I was there, and my grandmother died, and we went south, and we stayed a little longer than we had thought, and then I didn't go back when I came back.
What did you major in college?
And well, I was going to, at Buff State, I would have been a teacher.
Yeah.
But when I didn't go back, as I said, it was now during the Korean War, I believe it was, the plants and everything, they were hiring and paying a lot of money, and I got a job making some pretty good money, and I was making more money than teachers were making with the overtime. Yeah. So I stayed working and didn't go back. So I was out of school for a while. And so it was later that when I met my present wife, and she was just graduating from college.
It's Ernestine?
Ernestine, yes. Yeah. I decided that I would have to go back to school, but I would only go back to be a lawyer. Now, the reason I wanted to be a lawyer was I had been interested in becoming an FBI agent earlier. And I had read all the books on how to become an FBI agent. And in those days, you had to be either a lawyer or a certified public accountant. So even in school, I took some accounting courses. That's when I realized I did not want to be a certified public accountant. And if I did become an FBI agent, it would be through the law.
So the law was really not an end in itself for you, but a means to becoming an FBI agent? Was that the idea?
That was the idea, because there were no family members or anything like that in the law. And but little did I know at the time, I couldn't have become an FBI agent anyway, because of Hoover. He didn't have any black agents in the FBI, and he would not have allowed me to become one.
So nobody gave you any indication that this would be a fruitless exercise, or?
Well, maybe, because I can remember my guidance counselor at Hutch, when I was telling him about what I wanted to do, he told me to become a machinist. So maybe he might have been, he just didn't want to come out and say it, but maybe he was right there at the time.
So when you ran into that wall, how did you change your plans?
Well, as I said, that's when I decided to go back to school. That's when I went back. I went to the University of Buffalo, and I started again from scratch. And that was my main purpose was to become a lawyer. And here I am.
UB Law, right?
University of Buffalo Law School, yes.
Am I right, class of 67?
Yes.
Okay.
Mm-hmm.
Any memorable folks in that class besides yourself?
Well, offhand, I can't think of anyone when you say memorable. The fellow that does a lot of building, he was in the class. I can't think of his name, but he other than him.
Were there any women in that class?
2, yes, we had 2 women, and I don't remember their names.
Now, Ann Michael, was she a contemporary of yours? Or
no, she's ahead of me, yes.
Ahead of you?
Yes.
Because I know she became a city court judge early on, as did you.
Yes.
Right?
Yes.
But before you became a judge, you were in private practice for, like 6 years, give or take?
Yes, around that, I was in private practice.
Tell us about your private practice. What kind of work did you do, and what kind of cases did you have?
Okay, well, starting out, I was going to specialize mostly in the civil area. I wasn't going to do criminal because, I knew a lot of criminals, and I felt a little
keep a safe distance.
So at the time, I was developing a pretty good civil practice.
Of what nature? Personal injury
Mostly
stuff?
personal injury.
Yeah.
Yes.
Now, I in your biography, I noticed that you had a lot to do with the general obligations law. Is it section 15108 about tortfeasors, and if you settle out with one, you don't release everybody else. How did you get involved with that?
Well, I was a judge then. I was a Supreme Court justice at the time I wrote that, and the reason being was in trying to settle cases, you would have 3 or 4 when you had multi-tortfeasors, and you'd have 1 or 2 the lesser tortfeasors wanting to put up their policies and get out of the case and cut down on their legal fees.
Right.
Plaintiff couldn't accept it, even though plaintiff would love to have taken that money. But if they did, the remaining tortfeasor, which we call the deep pockets, the one that was really into the case and had money, who would refuse to pay, it would stay in the case. And if you let the other 2 out, they put all the blame before the jury on those 2 that you let out.
Yeah.
And therefore, the jury has to apportion the amount of negligence on the part of each tortfeasor. And therefore, plaintiff would wind up, with say $1 million verdict, and only collected a couple $100,000 from the tortfeasors he let out of and then he come back with a verdict of only 50% negligence on the part of the deep top tortfeasor, and therefore the plaintiff is out of $300,000 and saying, well, where's my money? And the plaintiff's lawyer is saying, well, wait a minute, I didn't, and it caused all kind of confusion.
Yeah.
And it also protected those deep pocket, what we call the deep pocket defendants,
Yeah.
because they can say we can sit back knowing that we're going to have to pay, but we can cut our losses by letting these lesser defendants go forward, you know. And so that's why I said that law should be changed. And so really, I wrote that to say that that law should be revised.
Did you get a lot of pushback from the defense bar on that?
Well, I got a lot of encouragement from the plaintiffs bar, that's for sure. But, you know, the legislatures are not going to do anything in favor of the plaintiffs. You know, they, for the most part, most legislators are conservatives.
Yeah.
And the last thing they want to do is, if there's going to be some extra money, put it in the hands of the plaintiffs.
Yeah.
And because that's what would happen, is that if plaintiffs settled out, you know, and they'd taken their proceeds up front, then whatever they got in the final verdict, they would be able to keep also. But this, the way it is now, is that the defendant gets the advantage.
Yeah.
By not settling, he gets the advantage. So therefore, I think the title of that article was "The Unsettling Tort Law," or something to that effect. It prevent the settlement of cases.
So in your private practice, were you pretty much on your own with a partner or associates, or how did that work?
No, I was a partner with Cerati, and Cerati was the name of the firm. Right out of law school, I went to work for them. And within a short time, I became a partner. And we were pretty successful. In fact, we had one of the largest, at that time, negligence practices in the area. Because, you know, we used to have to file those retainer statements in those days.
It was long before the advertising days.
That's right. Well, we would file more advertising statements than any other lawyers at the time we were practicing. So we had a very, very successful practice. And that's when, as I said before, I didn't want to get into the criminal. But what was happening is a lot of our civil clients would get arrested, you know, have problems. And if you sent them to another lawyer, if there was another accident, they wouldn't come back to you. They would stay with the other lawyer.
Well, funny you should say that. Richie Barnes, who's now the head of the Barnes firm,
yes,
was at a small plaintiff's firm back in the day, and he said that he got a nice settlement for a plaintiff on a case. Or I'm sorry, he represented a guy in a DWI, got a nice result, and then a couple years later, the guy gets in an accident, and Richie goes, "Why didn't you come to me? You went to my brother." He goes, "I didn't know you did plaintiff's work."
that's
so
right. Yes.
He decided very quickly he's going to join that firm. So, so you were there for what, 5 or 6 years?
Yes.
With the firm.
Yes.
And so, how did you get the judicial bug?
Oh, well, that's another story. I did not want to become a judge. In fact, I turned Joe Crandall down 3 times. They kept asking me to become a judge. We had a very, very busy practice. Making a lot of money.
Yeah.
A lot more money than judges made.
Yeah.
And so I had to start thinking about it, because many times I would sit in the court and I would see some of the judges do things to some of the people, especially the black litigants, and it just really used to upset me. But then I said, you know, you're saying it upsets you, but yet still they said for you to become a judge, but you're saying, no, I make too much money, and so I'm being a hypocrite.
Yeah.
So I thought about it, I talked it over with my wife, and decided, okay, maybe I should do it. And so that's...
So in 73, now, did you take an appointment first and then run?
Yes.
Okay. So the mayor at the time was who? Frank Zedita? Stanley Mikowski.
Yes,
Okay.
Mayor Mikowski.
All right. So then you had to run that same year.
The next year
Yeah.
I ran, yes.
And you got elected to a 10-year term.
That's right. I was elected, but
I noticed in your career you seem to have a rule of 5s.
Yeah.
Meaning 5 years in private practice city court.
Yes.
Then you were there for 5.
Yeah.
And then in 78 you decided you're going to run for state supreme, right?
Yes.
Before we get to that, very quickly,
Mm-hmm.
how did you find being a city court judge?
I loved it. I love being a city court judge, and I've told the story many, many times when I've been asked about my career in the law as a judge, which position I felt that I cared for the most, or I felt I did the most good. And I think it was as a city court judge, because there you can really work with the litigants, with the people. You can help them, you can get them straightened out and put them on the right path and do things. You know, when you get to the felonies in the higher courts, you have to cross the T's and dot the I's, and you can't.
Your options seem to be more limited.
Much more limited.
Yeah.
So I was able to work with a lot of the young people. In fact, in 1977, Canisius College honored me with a Doctor of Humane Letters because of my work with the young kids.
Yeah.
Mainly young girls that were getting involved in prostitution. And I set up a teenage prostitution program. And
I think Judge McLeod kind of took a lead from you in many respects.
Yes.
So in terms of the way he interacted with the younger kids from the neighborhood and trying to get their minds and their heads right and in the right direction. At least that was my sense of it.
Oh yes. Well, for years I would have young people come up to me afterwards and say, "Judge, I'm a teacher now. Judge, I'm a nurse. Judge, I'm this. Judge, I'm that." Things you say about,
Yeah.
But that's why I felt, city court was so important. Now, Supreme Court was okay too, but in Supreme Court, I didn't do the criminal. I don't know if you knew that, but.
Well, I was going to ask you that because
Yes.
I know there were some judges like Forma who hated the civil, loved the criminal.
Yes.
Stuff.
Well, no, that wasn't the reason why. My reason was I didn't want to be giving out those long sentences.
Yeah.
And those mandatory sentences and all these things, and people didn't realize, the ministers and the politicians and that wanting you to help. You can't with a mandatory sentence. Yeah. And so I felt, I just assumed do something else. So Judge Baker, in 1978, when I got elected to the Supreme Court, he contacted me and asked me to come with him because he was setting up the medical malpractice part of the Supreme Court.
Yeah.
Because there were some 450 cases that were just idle. Judges were afraid of them. They didn't want to touch them. Yeah. And so Judge Baker was going to run this. And so he asked me to come in with him. And I did. And he left me after about 6 months later. He went into something else. So
Dumped it on you.
Yeah, but so for the 4 years or so that I was on the Supreme Court, or the 5 years, I did medical malpractice. In fact, I did all the medical malpractice for the 8th Judicial District. And, brought the calendar down to, almost zero.
Tell us briefly about that race, though, in 78, because as I understand it, you were the first African-American jurist outside of New York City to win a Supreme Court election.
Yes.
Which is no easy task under any circumstances. So how'd you pull that off?
Well, there were 10 of us running for 5 seats. And it was very difficult for me to get a advertising person here in Buffalo to run my campaign because they said that I shouldn't go on TV, and that I shouldn't put my pictures on signs, et cetera, et cetera.
For racial reasons?
Yes, because of the 8 counties that you're running in.
Right.
And the total population of the vote that I would need, I think the blacks only made up less than 10% or 5%. So I went to, I didn't, but a good friend of mine, Richard Joyer, his company, they used an advertising firm out of Toronto. And him and I were friends, and so he says that, geez, let me talk to this guy, the advertiser up there. And he did, and he said he hadn't done an election campaign, but he'd be interested in it. Yeah. So he came down, and we discussed it, and so we hired him. So actually, he's the one that ran my campaign.
Now, wasn't he also Dick Arcara's guardian angel, so to speak, or is that another Joy?
That's the same Joy, the family. That's the same family, yes.
So when they got behind you, it usually took good result, right?
Oh, yes. So what happened is, out of the 10 candidates running, I ran number one ahead of, all the
You remember
candidates.
some of the names who were in that race at the
Oh
time?
yeah, oh yes. See, Judge Roberts was in there, Judge Fallon was in there, the judge, I can't think, he was a county court judge, well, I can't think of his name, but Bestry was there, and so the winners of that was I just mentioned his name earlier, but Vinnie Doyle, Hank Gossel, Broughton from Niagara County, and myself and Mintz.
But
So
you came in number one.
I ran number one, yes.
Wow.
Mm-hmm.
So, what do you chalk up your success to?
Well, I went to all these places that they told me that I shouldn't go. We went on television, and I just spoke to the people. And
Did you encounter racism at the time?
a little bit, but I would make it fun. I would go into a place, and like in one place, out here in Orleans County, it just so happened that there was a person running for district attorney at the same time, and his last name was Green. So when I get up, for the audience there, I says, let's cut this rumor down, contrary to some of the things that's flowing around here. John is not my relative, and things like this. And, they'd fall in love, they'd laugh about it. I had one which was very, Schimminger. In fact, when Schimminger, I think it was his first run for the assembly, and out in Kenmore, I remember being out there, and I remember him making this speech against his opponent that he was running against for the assembly, and he was calling him the Black Knight, and he was going to ride into Albany, and he was going to clean it up, and he was going to do this, and he was going to get rid of this Black Knight, and he's going to do blah 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 blah. Well, just so happened the next speaker was they called on me, so I get up and I said, well, first let's make it clear, I am not that Black Knight. Now you gotta say these are all white people, but
Right.
They laugh. But then they talk about that later, and they say, hey, Sam, this guy's
all right.
So based on that, I think by appealing to the people that way, I got their vote. And I would always ask them, I said, just give me your second vote. I know you have a favorite.
Your approach to politics, and I'm going to guess life as well, in terms of defining who you are and your success, reminds me a little bit of Charlie Pride in this respect. He was trying to break into country music in the early 60s, mid 60s, and most people were saying, well, we can't have a black guy, good voice or not. They loved the way he sounded, but they just were concerned about, well, what's it going to look like if we put him up on stage? But he took a very easygoing, affable approach to it with a good sense of humor, picked his battles, and he picked his openings. He had a few guardian angels along the way, and for him, the rest was history.
Yeah.
But as I'm listening to you tell your story and how you were able to move up the ladder, so to speak, the parallels kind of jump out at me. So 5 years on the trial level of Supreme Court, and then 83 you're appointed to the
Yes, in fact, that was
appellate division.
Yeah, what happened was, I was asked by Judge Kane, the administrative judge at the time, if I would go to New York City and try a big medical malpractice case they had there. And most of the judges were disqualified because of this case in New York. And they had asked him if he had someone, and he asked me if I'd go down, and he says, a couple of weeks. And I says, sure, I'll do it. So I go down 4 weeks. I was into this trial for 4 weeks.
Yeah.
Took a $4.5 million verdict, and that was in 82, 83. And that was
$40 million today.
Oh, that was a lot of money, and so I go back, and when I finish, I was gonna, there was only 1 or 2 days left for that term there. So I said to the clerk, well, look, I'm gonna stay at the hotel, so if you just call me if you need me, but otherwise I'm not gonna bother to come in. Well, I get a call, and there's the state police calling me, telling me that they wanted to talk to me. I said, for what? This was, I don't know, something had to do with the governor. And I says, well, I don't know for sure when I'm coming back, because I was leaving there going to the Bahamas, and Ernestine, my wife, was going to meet me in the Bahamas. And so I says, well, I'll get in touch with you when I get back. And then about 5 minutes later, the phone rang, and it's Mike Dillon, who's the presiding justice at the television.
Kevin's dad.
Kevin's father, yeah. And he's saying, what are you doing? What do you mean? You got to get back here. You're going to be sitting on the appellate division next week. I said, what are you talking about? Well, the governor's appointing you to the appellate division.
This is Mario Cuomo, right?
The father, yeah,
father,
Mario Cuomo.
Yeah.
So I was appointed, yes, to the appellate division.
So now we're getting into Nick's bailiwick here.
Okay.
He's an appellate lawyer who actually understands what goes on.
Yeah.
But you were there for 28 years, right?
A little over 28 years,
Right.
almost 29, yeah.
Can you explain to the lawyers, and I know defendants in criminal cases have an appeal as a matter of right, and you get a slew of cases, but I'm curious if you would take us through how you, along with either your clerks or fellow judges, would go about reviewing, analyzing, and deciding a case. And then
Yes.
I'm going to let Nick kind of take it from here, because this is his
Yes,
area.
what happened is, there are 5 of us that sit, okay? And you know that, for those that are listening, we have judges from Syracuse, Rochester, Buffalo, and some of the areas in between, but it's the Western District of the state. And we have the briefs are sent to our chambers, briefs and the records of the cases that are assigned to us. And the way we sit here, it's in the 4th department and the 3rd department, we do it differently than they do it in the 1st and 2nd departments in New York and in Brooklyn. They sit every day, their courts sit, the appellate division. We sit in what they call terms of the court. And I think we have like 8 terms, 7, 8 terms a year. And they're usually 2-week terms. So now, when I went on the bench, I think there were maybe 9 members. I think maybe now there are 12. Yeah, okay. So what they do is the presiding justice draws up panels for each day of sitting, 5 judges on that particular day. And as I said, you would maybe in a term, you would sit 5 days or 4 days or whatever it is, 6 days. In the old days, we used to sit sometimes 10 days. But you would get the cases, and every 5th case would fall to you to write. So if there were 20 cases, that means there's going to be 4 cases that'll fall to you. 25 is going to be 5. But what I mean, they'll say, well, I'm going to write a dissent. And then you see what the other 3 members are going to do.
So you would have to write majority opinion first, show it to the dissenter who would then respond, or how did that work?
Yeah, well, it could be that way, but what will happen is before you start to write, you know what the panel is going to be. You know whether or not this case is not a mistake. This is a pure and simple fabrication made out of whole cloth. And when I said that, he went back on his heels. And from that point on, it was Judge Green. For the next,
He got his attention.
next 20 minutes, I get his attention. For the next 20 minutes, he ignored everybody else on the bench. Judge Green, Judge Green. And I remember because when I got off the bench, I went into the conference room, and we had these huge library dictionaries and things. So Judge Denman was in there, and I said to her, what does whole cloth mean? She says, I don't know what that says. So we go into it may just something that's made up out of the sheet. And so, but then everybody was saying, Sam, that case is not going anywhere. Everyone said it wasn't going to go anywhere, right? So I said, nah, I'm staying with it. So I wrote it, and I had trouble holding my third vote. Two strong dissents. So there was one problem when I wrote the case. The judge told the jury that the story was false. And the judge should not have told the jury that. He should have left that up to the jury himself. In defamation cases, they want each court, each level, has to look at it on their own. So I wrote, it was error for the court to have told the jury that the story was false. However, had the jury found otherwise, I tried to bootstrap it, so I wanted the Court of Appeals to know that we had looked at it, right?
Treated as what, harmless error?
Well, when we affirmed it and sent it up, they affirmed the case, and they reversed. They reversed and said, we reversed solely on the issue that the judge said that the story was false.
So they agreed with your reasoning otherwise, just that the judge went too far?
They knew that this case had a chance to go to the Supreme Court. And that's why each court in a defamation case has to make their own findings.
Yeah.
And for that reason, that's why they had to do it that way. Yeah. So they sent it back, but they did the plaintiffs a favor because the first verdict was mostly punitive damages. I think that some 12, maybe 11 or 12 million was punitive. When the case came back, they had to they retried the case. When the case came back, this, what's his name, was so sure he was going to get this case reversed, Abrams. He allows Baker to put in all this proof of, loss of earnings from a hotel that he was building. He had a boat that was going to fly to Toronto across the water. He had an airline, plane that was going to go to New York. All this, he put all that evidence in. There was no objection. It came in, and so therefore, when the verdict came back, it was, I think it was around 18 million. And there was 500 punitive.
So he lost for winning in the long run.
Yeah, so then they as I said, so the big argument now when they come back, when he comes back before us, is that it's excessive. Well, you can't argue it's excessive. You didn't put any challenge to the, so then went to the Court of Appeals. The Court of Appeals couldn't take it because it was a factual issue. They want to take law. So the case was affirmed. So that was one of the big cases.
So your description of the lawyer and how he was conducting himself until you got his attention, I think raises a interesting point or question, which is, who were the lawyers? I don't mean the names, but what were the qualities of the lawyers who you thought were the best appellate advocates in terms of how they presented themselves, how they responded to the judges and so on, as opposed to those who weren't so effective? Because clearly this guy got your attention in the wrong way by ignoring you until you hit him between the eyes. But you've seen a lot of lawyers, I assume some very good ones, some not so good. Who are the ones, in terms of how they conducted themselves, that got your attention, and why?
Well, the good lawyers are those lawyers that on a regular basis, they do appeals. It's really not, I don't think that the lawyer that actually tries the case a lot of time, I think they're not as effective on the appeal because they're still trying to persuade, and the persuasion deals with facts. We don't deal with that many facts. We're looking at it from a legal standpoint. Because, you've had your shot with the facts. You had a shot with the judge and the jury, and they've decided that already. Yeah. So now you're telling us that they were wrong. You better come in here and show us legally that they're wrong. You see? And the pros know that. Those that are really good can come in. Well, now, you naturally need to know some of the facts because you got to set up the law. But they know how to do that. And they don't burden you down with being repetitive and saying and arguing, and the judge shouldn't have allowed this, and your judge. So we're really not interested in that. So those are the good lawyers. I mean, the appellate lawyers. They can come in, they know pretty much, and they're looking at you and they're waiting for you to ask them a question. They want you to ask a question. So you see a lot of the inexperienced appellate lawyers. They come up. They got a list of argument that they're going to make, and they already, we've got the briefs. We really don't want you to repeat what's in the briefs because we've stayed up and we've read those briefs, and I don't want to listen to you tell me about what's in the brief. And I was known to always jump in and cut them off anyway. I just jump in and say, what you're saying is.
It's nodding his head.
I
I think he may have had a habit.
I can attest to that. It's funny because when you kind of broke into your judge voice about how you were talking to that big shot lawyer from New York, I was thinking I could actually picture you saying, talking from the bench like that. You would always cut somebody off and say, no, I want to get to the real point here, which is blah blah blah. It was but I think it shortened the time of oral arguments for the day when you're getting people right to the point, what the court wants to hear, right?
That's the whole idea, yes, because we got 20 cases on that calendar. I mean, you got 40 lawyers, or 25, you got 50 that you got to listen to if you listen to all of that. But as I said, they're really not. A lot of time, if they're just looking at their yellow pad and going over, which, let's get to the point. What you're saying, that court erred, the court should not have done this because so-and-so versus so-and-so don't stand for the proposition. Is that what you're saying? Yeah. Well, what about so-and-so? Have you, blah, 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 blah. Now let's get into it. Now you're talking and you can, then you say, okay, well, let me see what your opponent says. Then when the opponent gets up, you can say, well, why isn't this and so he's right. This should not have been, the case is so and so, so and so. And so you get in there, then you get it, and you cut down on the time. You know where you are.
What percentage of the time when the judges take the bench for oral argument, then they already got a pretty good idea what the outcome's going to be?
Well, we know on that particular case what the recommended outcome is going to be when we take the bench. But that doesn't mean that that's going to remain because you can change your mind.
Does that happen occasionally?
It happens quite a bit. In fact, if I'm in disagreement with you, you see, I use that as part of my questioning.
Yeah.
So my questioning is a lot of times is I'm trying to bring you to my position here, or I'm trying to make if I'm for you or against you, depending on whichever it is, I'm using my questions to so that now.
So in some ways, the appellate judge becomes the advocate for his own position through the lawyer who's arguing.
That's exactly right. Because the fight really is not out there in the courtroom. The fight is back in the conference room. Once we go back into the conference room, that's where it's knocked down, drag out, I mean, name calling, everything. Oh, it gets, so they take it serious. Now, most lawyers think that, the judges, they take those cases very, very serious. And when you go back there and you call for the vote, you better know what you're talking about because you're going to get embarrassed. And, so therefore, a lot of times you'll say, well, don't you remember when I asked the lawyer, what did he say? This is what he said. And then the others will say, well, so this is how you bring them around.
So I think you may have answered this question then. So the oral argument is not just window dressing?
Oh, no. Oral argument, definitely not window dressing. As I said, I wouldn't even want to be on as a judge if you didn't have oral argument. Just to sit there doing those papers back and forth. But the oral argument is if my feeling is if you think strongly about your case, you got to get up there, because even if you don't have that much to say, but be there in case I have that question. Be there because a number of times where you said, "Gee, so and so didn't appear, or she didn't appear. I wanted to bring this out. I wanted to get this fun." Said, this is the oral argument is very important.
Now, one of the things I've noticed about appellate division, not just the fourth department, I think pretty much across the board, if you compare an appellate division written opinion to a court of appeals opinion, and I understand different roles, and oftentimes when the court of appeals writes a decision, it's because they want to settle some law over which there's conflict in the departments. I also noticed, for example, that when the lower court judges, present company including, would write, they tended to write on and on and on, as if to show the higher courts how smart they think they are. But my point is that oftentimes in the appellate division decisions, they don't always show their work, like in a math problem, if you will. They'll cite a case, reach a conclusion, but you scratch your head and say, well, how'd they get there? And I'm wondering, is that a function of volume, that you don't have that much time to expound as, say, the Court of Appeals might? You just get to the point or you only write when you have to?
Well, you only write when you have to. One of the, at a mid-level appellate court, as I kind of mentioned that before, is that you have so many of these cases, and, there's only so much you can say because it's been said. And when you, speaking of cites, you have, these string citings, and just about everything that you said is, it's been said already, so why go and repeat it? Yeah. As I said, it's one thing to write on this new area, this area where there was very little law on it. No one's really, challenged it, or no one's really gotten into it, It's completely new. A case that I had with John DeFranks was a case where they got a conviction of a defendant without the body.
That was Nelson Cosgrove's case. They found some bloody tissue on the side of the road. That's right. State police. I can't remember the name now, but I remember there was a visiting judge who presided.
Okay.
Yeah. I remember that case.
All right. Now there's a case in New York. We didn't have that. There was no. Let me just. Turn this off. Delete that. Turn it off. I'm sorry. I forgot it. But yeah, now here's a case. There's no, in the whole state, there was no case. There was one case where there had been a conviction for murder, where they had not found the body, and that was a young woman out of Rochester who was a prostitute, but the defendant had pled to it. He just couldn't find it. When the policeman took him back to the area that he buried her, he couldn't find the grave. So, but they had her shoes and they had some other stuff, and based on his admission, that was a conviction. But other than that, this particular case was the only case. Yeah. So now, I wrote that case, but in that case,
was affirmed, right? Conviction.
Oh yes.
Yeah.
In fact, I was shocked. It was affirmed without them accepting it. They wouldn't even. The Court of Appeals wouldn't even write on it. They just affirmed it, which I was expecting to get, a load but.
And they must have felt you said what needed to be said.
Well, we spelled that case out, and we really laid that one out like a roadmap, the way you speak, because I knew it was a circumstantial evidence case, and we had to make sure every link was linked up. So therefore, in those type of cases, yes, you take the time to do it. Yeah. But in the regular automobile, the slip and fall, all those things, what are you writing for? What are you saying? You're not saying anything that hasn't been said. Every now and then there's a new quirk or something, or you want to push it. It's okay, even if sometimes you're trying to push it, even though it's fine, but you get knocked down real quick, or you could never get through.
Yeah.
How did you become known as like the search and seizure expert?
Well, what happened is, I don't know if I was an expert, but
well, that's what everyone always.
On the bench.
In case you don't know.
Everybody
always talks about.
Okay, why they do that? Yeah, I guess right. I would cite the cases right off the bench. Oh, Oh, I was thinking about you when I was trying cases when I was a lawyer.
Oh, okay.
Okay, yeah.
No, when you were the
Okay,
judge.
yeah, okay, you're right. I did. I knew all the case. I just had worked, as I said, when I was practicing law, the kind of clients I represented, the only way you can win those cases was you had to suppress the evidence. For drug cases, for gambling cases, for possession of weapons, all of those cases, the policeman caught you with it. you possessed it.
Mhm.
What is your defense? You know? So the only way you can win the case, the possibility is suppress the evidence. The policeman had no right to be there to find it. In other words, challenge the officer's ability, to have checked you or seized you or whatever. And so, that's what I used to do just about every case. I'd bring a motion suppressed.
Mhm.
And you get to know the cases.
Did you also become familiar over time with like certain police officers who you kind of red flagged as someone you need to take a closer look at
Oh,
the
yeah.
record because they had a way of tailoring their testimony?
You knew that, you know exactly who they were and how they were, and they would change their testimony according to the way the law would change.
Yeah.
I'll give you a good example. Pew versus Corrado is an old case that had to do with manila envelopes. It said at one time the policeman would just come in and say, "Well, I saw the manila envelope on the seat." Well, automatically everybody knew it was grass, right? Marijuana. So then the Court of Appeals said, "Wait a minute, no. The mere fact that you saw that manila envelope in and of itself doesn't give probable cause, because that manila envelope could be used for other purposes. Could be for church collections, or could be for." So then all of a sudden, what do you think the cops say now when they come in? "Well, I saw the envelope lying on a seat with green vegetable matter spilling from it."
Yeah.
So I mean, they're all going to try to get around it.
For the longest time, the smell of marijuana was always a big open door into the car.
Yes.
Now that's going to be more problematic because these new marijuana laws. So it seems like it's becoming a little more difficult than ever before than it was to be a police officer. With no-knock warrants, they're trying to significantly reduce those.
Well, that should have been the case, but with no knock warrants, I in city court, we signed a lot of warrants, but I was very, very careful about signing no knock warrants.
Because
And well, I just they're just dangerous, going into people's house unannounced, and you don't know who's or what. And I was also, back in those days, a lot of the policemen wouldn't come to me because they knew that I was going to be very, very restrictive. And I really wanted to know, what is the probable cause? What is it? I didn't want these cops. One cop being the informant. You know how that is. The informant is really another cop,
Mhm.
and the informant tells me yes. So I used to really put them through the ringer, and it's getting to that now, and it should be, because look, everyone wants good policing, but the policemen, all of a sudden, if you allow that, they get careless, or they just take it for granted and use that badge to be, and then it's accepted by most of these judges. These judges are sitting up there knowing that these cops are lying. If they don't, they shouldn't be on the bench or in the place they are, because of these stories and things that they're telling. And they go along with it because they're cops. Well, that's not justice. That's not fair. And I'm not saying that just because of what's going on today. I mean, I've been this way, going back to the 60s and the 70s. I've been saying these.
Yeah. So do you think that your experience as a private lawyer, to the extent that you did some criminal work, informed the way you analyzed these Fourth Amendment cases when you were on the bench?
Oh, yes, I'm sure. Yeah, it had a lot to do with it. Yes. Yeah. Yes.
So, if you were giving a commencement speech to law students, and they want to get into criminal law or whatever practice, what advice would you give them to young lawyers coming up in this world that we live in now, this COVID, post-COVID, hopefully, world that we're living in? What advice would you give them about lawyering and what they should do with their careers?
Well, personally, I think that I would not try and direct a young person into any particular area. I think they have to get that feeling themselves. And once they get a feeling for a particular area, start to work and get the expertise. And if they, like it, they stay with it. If they don't, they move into something else. Because I think that if you think, well, as I said to you before, I was going to be a civil lawyer. I was not going to do any criminal at all. And but as soon as I got out there, and my clients started to, as I said, get in trouble, then I started to represent them. Then all of a sudden I got good at it. And you win a few. That's when you get good, when you win a few. Then they all come, they start coming. And so in my day, it was kind of unique because the young blacks, or the young or older blacks, didn't matter. They wanted to see a black lawyer that they could trust, that they could go into court with, you know what I mean?
Sure.
That they felt that, hey, I got a shot. And so then I had become almost like a, what's the word, but whatever it was, they would go out and the young criminals would brag about, say, yeah, Sam Green's my lawyer, you know what I mean? In other words, that's good to have that type of reputation,
Oh, yeah.
And so that's why I would not try to guard or to direct a person into any particular field, because as I said, the law is something that they say it's a jealous mistress. I believe in that.
Murphy used to say that a lot.
Yeah, I really do. Because once you get into a case, especially when you start trying cases and you're trying jury cases and things, your whole life you're taking over. During that period, you don't want to talk to anybody about anything else. That case is your life. And we used to have a lot of that, but we don't have much these days because most cases today are pled.
Yeah.
But when I first started, there was no pleas. You didn't plead cases. You just tried. But there were so many trials going on around here.
Who are some of the memorable trial lawyers? I can think of a few, but the larger than life characters, they're few and far between these days, don't you think?
Well, you had Mahoney.
Yeah.
You had Condon. You had Farringer. You had one lawyer that very few people knew about was Frank Reichley. You had McDonough. Now, that Frank Reichley I mentioned, Roy Cohn hired him to represent him when Roy Cohn, the big Roy Cohn in New York, when his lawyer died in New York, he was being prosecuted for something. He came to Buffalo to get Frank Reichley to be his lawyer. That shows you the kind of lawyer he was. Then you had Harold Boreanaz. And you had, I can just go on and keep naming, all these.
What qualities do you think they had in common? What made them so good?
They were in love with the law. They did, and back in those days, you talked to law all the time. Like there were certain restaurants, the criminal lawyers, they would all be there. And then like you had motion terms and different criminal motion terms, and all the lawyers would be together. And then, it was totally different atmosphere than it is today.
I mean, now there isn't an atmosphere. I think in large part because of the COVID thing, everybody's in their own little boxes. And Dan and I were talking earlier about, well, witnesses are supposed to be wearing masks when they testify, right? So how can you ask a jury to gauge someone's body language or their facial expressions when they look like a bank robber on the witness stand? So everything is so topsy-turvy now. And lawyers, I'm not saying there aren't great lawyers out there, but you don't see the larger-than-life characters anymore.
No.
The true trial lawyers who we're trying cases left and right and
Oh,
persuading
you would
juries.
have in any week 5 or 6 cases, serious criminal cases going on in Buffalo all the time. Because, in fact, I went to law school across the street there on Eagle Street. And, a lot of time between breaks and things, you just run across the street. And you could go sit in on a major criminal case just about any.
What do you think changed? Do you think
Well,
we got better plea
please,
offers, or?
please, well, just about everything is pled. It's, it's so rare that you get a regular trial. I mean, how many cases do you see where they really go through the full trial? It's just.
When you had to read the transcripts when you're on the appellate division, you're thinking back and you were a successful trial attorney. Did you ever you're reading it and you're like, oh, I wish you wouldn't have asked that question, or I wish, you ever find yourself critiquing the lawyers as you're reading the transcripts?
Oh, well, you critique lawyers all the time. Yeah, I remember this is not a critique really, but I had Paul Cambria up, this is going back a few years, but he's representing a big mafia case out of Rochester. And usually when I get a case or something, a big case like that, I'll take it myself and I spend some time with it before I give it to my clerk. And I had worked on this case, and I said, geez, the only chance he had, this defendant, would be if such and such. But he had admitted to this in some statement that he had given. So I'm saying, geez, there was just no way you could get around it, right? Mm-hmm. So now we got the argument, and you've been in court, I'm sure, with Paul. And,
Yep.
Paul walks in, Paul Cambria, blah, 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 blah. And he gets going, And so he's going. And so I give him a while. So I said, Mr. Cambria, I can appreciate what you're saying. But your client admitted to something. No, he didn't admit it. I said, yeah, Mr. Cambria. He said, no, he didn't. He's got a record. The record's about 1,100 pages. So he's flipping through the thing. I said, it's on page 976. He turns to 976 and he goes, right? Then I said, okay, come on, let's move around. Well, it wasn't 966, it was the 977. He said, okay, he wasn't going to be outdone.
Yeah.
But things like that, but now that's not a critique of him because he is the best. I mean, he is good. Yeah, he is good. In fact, he tried his first case in front of me.
Really?
Oh, really? First case.
Was this in city court or Supreme?
City court.
City
No,
court.
it was city court. Yeah.
Criminal case?
A criminal case. It was one of these. They were trying those nude. What do you call them? The nude cases, nude movie, nude.
Oh, the pornography.
Pornography case.
Yeah, I had one with him in Depew, PJ Video.
Yeah. Okay.
We had that one. I remember we did the argument in front of Judge Henry Wick at the time, and then that case went all the way up to
Supreme Court.
Supreme Court.
Oh, that made law now. It's
Yeah.
PJ Video.
Yeah.
That in fact that's what determines that the state can set the ceiling, but the Supreme Court will set the floor.
Yeah.
Mm-hmm.
Yeah, and he ended up kind of making a part of his career out of that.
Oh, Paul?
Representing
First
yeah.
Amendment. Yeah, he's
that
still
entire industry.
Yeah, he's still the
Yes.
go-to guy in First Amendment cases.
Yes. Oh yeah. Yeah. No. But in that case, I always tell the story. In fact, he tells this story himself. We had waited for the city court to send the jury over from the county hall. And the young district attorney, Paul, and I were standing there talking. And I says, well, is there any problems, anything that we need to, before we get started here? And he pops up and said, well, of course I'm on appeal. And I look at him, I say, what if you win? And I go, I says, you little son of a bitch. You're going to come in here and threaten to beat me. You understand? he tells that story now. And Farringer had taught him, always ask for reasons when the judge rules so you can get your reasons so you're going to, the record is protected, right? Mm-hmm. So we're into the case. SI rule against some things. He interrupted. Your Honor, come approach the bench. Yeah. Your Honor, can I have the reason? I said it was bullshit. He said,
love it.
I had to go back and tell him. But those are some of those things.
Well, I think we've gone a little bit over our time, but I'm glad we did. I'm guessing I know the answer to this question, but if you had to do your career over again, it's probably not what you do differently, right?
Oh, no, I loved it. I love the law. Yeah.
So, no regrets about anything.
No regrets at all.
Well, thank you so much for spending your time with us. It's been most enjoyable.
Yeah, I mean, honestly, for me, it's an honor. I remember being a 26-year-old attorney starting off in appeals, walking into the 4th Department, and, you know, there's all these larger-than-life figures, and you were one of them. And it's a great experience. It was like maybe the first 7 years of my career was that. So it's amazing to be able to just sit and have a conversation with you. It really is.
Thank you for the comments. I appreciate that. I enjoyed, as I said, I enjoyed every bit of it. It was great.
All right. Well, thanks everybody for watching, and we'll see you next time around. Thanks again.
Okay, and thanks for the gifts, by the way.
Sign Council Schwag.